You've repeatedly failed to appear for court. You've repeatedly tested positive for a lot of substances, and now you're trying to fool us yet again. It's unacceptable, and there has to be accountability.
Oh, sorry. And this is his mom, Rosanna Tyrell.
Are you familiar with what he did today?
We're familiar with what they said. We don't agree that that's right. We also agree that he's being held accountable for things that aren't really applicable in this case. You know, and he's
I'm asking him not to use drugs or alcohol.
I know.
That's all I'm asking him to do. And he's constantly testing positive, and now he's taking a Whizzinator into the room.
Well, it's wrong. So we don't want
He can be charged criminally for that. That's an offense in and of itself. Falsifying a drug test, it's a Class B misdemeanor. You're facing another 6 months in jail.
Welcome back to the courtroom, and buckle up, because this one is pure chaos. We've got a defendant with missed court dates, positive drug tests piling up, and now an alleged attempt to cheat the system with a Whizzinator. Yeah, you heard that right. A fake device smuggled in to beat the test. The judge wastes no time reminding everyone. Sobriety compliance is the line in the sand, not the felony charge yet to come. What's at stake? Jail time, higher bond, and credibility. And what's coming? A brutal series of warnings, a father's desperate pleas, and a judge who makes crystal clear that excuses will not carry the day. Stick around, because in just a few minutes, smirks turn to silence, excuses flip into handcuffs, and instant karma lands harder than ever.
I think what needs to happen is I think the first thing you need to do is you need to talk to your lawyer before you make any statements.
Yes, sir.
The only thing I'm going to say is that I'm extremely upset, disappointed, and taking you into custody. You know, you've repeatedly failed to appear for court. You've repeatedly tested positive for a lot of substances, and now you're trying to fool us yet again. It's unacceptable, and there has to be accountability. And you need to accept that you can't continue to do what you're doing. Mr. Terrell, you're digging yourself into a hole that you cannot crawl out of. This monkey on your back will be there for the rest of your life.
This is the judge laying down raw truth. He's telling the defendant straight up, keep living this way, and you'll be 70 years old still chained to addiction and bouncing in and out of custody. It's not subtle. It's a warning about a lifetime sentence of failure if change doesn't happen now. This isn't just a legal scolding. It's a psychological hammer. In court, that line, digging a hole you can't escape, is a wake-up call. The question is, will the defendant hear it as a lifeline or as just another lecture?
Enabling it, or you're closing your eyes because of the...
Here, the father begins painting a picture of ADHD, Tourette's, and failed rehab care. This is a common defense angle. Blame systemic gaps, not the defendant's willpower. And to be fair, untreated ADHD combined with addiction is real clinical quicksand. But courts walk a razor's edge. Sympathy doesn't erase responsibility. Viewers, what do you think? Is the father's love helping here, or just fueling denial?
Of his chemicals and his dopamine chemicals in his brain, and he uses drugs to put them back. And I said the Tourette's makes him not make good decisions. It's not a good combination. And they said yes, that's the case in almost many drug addicts with ADHD, and they wouldn't fix it, right? And so I got pretty upset with him because he got out and he had a pill bottle that he got the day he got out. They had never given him any pills the entire time he was there for these things. So I agree that it's a bad problem and a wrong problem, but I also agree it's not entirely his fault because he's got a chemical imbalance that nobody is addressing and never has. He's had this since he was a young child. They've addressed his Tourette's, but they've never addressed the ADHD. And I didn't know until I spoke to a doctor a week ago, or a couple of weeks ago,
The father is practically cross-examining the rehab centers, arguing they never treated his son's ADHD and instead left him self-medicating with dangerous drugs. He's right about one thing. Untreated disorders make relapse almost inevitable. But from the court's seat, none of that excuse is sneaking in a fake test kit. The bigger clash is this: clinical reality versus courtroom accountability. That tension drives this entire case.
So we tried to get him on Ritalin. They wouldn't do that because it's a substance itself, and they said that he could be abusing that substance. So we tried to get him on a secondary substance that's not abusive. We have fought for weeks, months, and we can't. We finally got him a prescription just as he's now out and back in trouble. So I only beg that we don't want to have drugs, right? But we understand that maybe there's some underlying compassionate issues, right? And I mean, I'd like to be sent in, but that doesn't work.
And it pains me because I think that as a father and as a mother, due to love, a lot of times, you know, and I don't know necessarily you, but people tend to kind of shut their eyes and become naive to the fact that they're using, you know, and I'm not talking about marijuana. I'm talking about cocaine. I'm talking about meth.
Be careless. He's got a license for marijuana.
So regardless,
any heavy drugs, the cocaine or anything that's going to cause him a lifelong problem, no. I want him off of that stuff. But he's been in rehab 3 or 4 times. That doesn't really work. So I don't know what does work.
You gotta want it. One of the main things is you gotta want it. But be that as it may, he's trying to fool us, and it's unacceptable. And there has to be accountability for it. I can't just let him go when you're using a Whizzinator to try to fool us. It's unacceptable, and there has to be accountability. And the problem is that I think that what we need to do now is have him evaluated by our clinicians to see how we go forward. So what I'd like to do is, while he's in custody now, I can have it done in a very expedited manner. I can have it done within, today's what, Tuesday? We can hopefully have a report back by Friday to see, at the latest Monday, to see how we go forward. Our clinicians can talk to him, and if he's honest, figure a way to go about doing this. And I'm going to tell you now, while I have him here, I can pay everything for you, so you don't have to pay for a dime. If you're on the outside, though, I can't pay for it.
We can forward you doctor's records and things like that.
My only concern and the only thing I want now is our clinicians to
Notice the pivot. The judge proposes a rapid in-custody evaluation. Fast, funded, and supervised. That's not cruelty, that's strategy. In custody, evaluations happen in days, not months. No running, no faking, no missed meds. The message? You want help? You'll get it, but it comes with handcuffs first. This is accountability welded to compassion.
Go do it right back again. And we're going to continue to do it until you're honest. But, you know, you can lie to me, but you can't lie to yourself. You can't be like this forever. At some point, you're going to be a habitual and you're looking at 25 to life.
I forgot what it is. Thank you for your patience, but
you don't have to. And I'm really, truly sorry.
He did man up and come in. He wasn't going to. We had to fight with him and beg with him. He didn't.
To come in.
He didn't want to.
Of course. No one wants to go to jail.
And because he said, I said, he's not going to put you in jail. He goes, yes, he will. And I said, no, he has a heart. He's not going to put you in jail. He knows that you have a problem. The problem is an issue. Stopping the thing that's causing this is the issue.
Your last name, Mr. Terrell?
Yes.
We've tried that. I gave him to you.
But he didn't. We tried it, but like I said, underlying cause, which we've only just recently found, or found that it may be, they've never treated.
I understand.
And
I
so
understand.
he's untreated and still being treated like it's a normal case, and it's not really.
I tried. I've given him back to you guys. I've asked him repeatedly to stay sober and not use, and he continues to do so. No matter how many times I give him to you, it's going to continue, and you have to realize it. And if you think that just him saying, okay, I'm going to stop, or the Ritalin is going to make it stop.
As for many people.
It may have. And yes, it may have.
So how long are you putting him in for?
I don't know. For now, I would like to have him TRAS to see where they go. My feeling is that they're probably going to say that he needs inpatient rehab.
Which he's already been to.
Not in the jail.
Yes, he has. You sentenced him to that last year. Why, Mac? We didn't put him in WIMAC. Did we do WIMAC with him?
But they never actually treated the symptoms either.
So
probation
we have other, if WIMAC didn't work, we have other facilities that we can go to. And we've got at least 3 to 4 different facilities, and we can continue to put them into each facility until it takes.
He has this felony case that this case is associated with this next week. Yeah. Of which
So
we're
will they
hoping,
release
we're hoping gets thrown out of court.
They have also facilities as well to help treat as well. We both do. We both have facilities. They have more resources than we do because there are more serious cases up there, so they have quite a bit of more resources.
It does look like he went to WIMAC, but that's mainly to address like this criminal attitudes and thinking. You know,
It was for drugs because he was on probation for drugs. That's why he was.
No. What she's saying is that
the program that he went to was supposed to address like this thinking, attitudes, and things. So now we're gonna assess him now that we know that he has mental health issues and as well as substance issues.
His went last time because of substance abuse. That's what it was for.
no, but she's saying no.
She said no, but this time
Okay.
it's
Well, I think, Judge, they might be referring to the deferred was adjudicated based off of drug violations. He tested positive for many times for drugs. That's why his guilt was adjudicated in that case in this court. I think that may be what they're referring to.
It was because he was on probation for drugs. And they actually, put him in there. And then, when he came, he couldn't even get his lawyer when he came to court. He got a court-appointed lawyer when he had a lawyer, he was paid for. And twice. And it was very frustrating to us that he doesn't seem to be getting fair treatment. It seems like he's being held as an example and be given as an example and not being given fair treatment. And
How is he not being given fair treatment?
well,
Tell me.
I guess we don't want to, my wife is not going to be happy if I.
Well, no, but it seems like you're blaming me for the situation, you know?
no, sir. What we're trying to say that he never got an assessment for the mental issue.
And they were told over and over again. I wrote
They.
the court officials, the probation officers, everyone was told that he had these issues and problems. They did nothing about it. Okay, his attorney brought paperwork to the court, Mike Mull.
Yeah, just we gave him the paperwork with all the.
Nobody did
tests
anything
and
about
stuff
it,
on him.
So we keep
So-
going, you guys keep blaming this stuff, but you just keep holding him up as an example and punishing him, and we never try to find out what's the problem.
Put people in jail when they violate conditions, when they do something against the law. We don't willy-nilly put people in jail for S and giggles. We don't do that here.
So why is
If
there?
someone has a true problem, then we give them the opportunity to try to do things on their own. When it becomes evident that they're unable to, that's when we try to step in. I don't do this out of hate.
Outside of he, we know that he has a problem, but outside of that, like he has a felony charge, they aren't giving these bond requirements. And this misdemeanor court is giving these bond requirements, when the felony court is not. So,
I can't tell you what the felony court, I want to make sure that he's not using alcohol or drugs.
it has nothing to do with this case.
How do you know that?
Judge, there are facts in this case that do indicate that there were crack pipes recovered from the defendant. And that's most likely why.
How do you know that he's charged with a felony assault? He's charged with interference with emergency request for assistance. How do you know that the drugs and alcohol that are using did not impact this?
Because he was sound asleep. All right, and she stuck a machete through his TV.
Not the
She, okay, I know, we're not
No,
supposed to
I
talk
mean,
about it. I apologize.
look.
It just feels very wrong.
I know that you see through the eyes of a loving father, and I'm not going to fault you for that. I get it, and I understand that, and I'm sorry. I really am. But I think that the best thing for him now is in a facility that he doesn't have access to drugs or alcohol. And I'm trying to do my best to keep him clean and sober. He tried to fool us now by using a Whizzinator.
This is why he didn't want to come in yet. He would rather be run, that's why he didn't want to come back.
Okay, and you can't run forever, Mr. Terrell.
I know, I tell, but.
So it's better to man up and get it done now than to run forever and do some irreparable damage by taking something that you kill yourself, right? Because that's invariably what's going to happen. The dope that you're using, you're going to kill yourself. He can barely open his eyes, man. This
Boy, I'm listening to everything you're saying, sir.
You're so high right now, you
There
can
it
barely
is.
open.
The judge calls it out in front of everyone. The defendant looks visibly impaired in the courtroom itself. Imagine the impact. Parents pleading for compassion while their son sits slouched, eyes half shut. This is instant credibility collapse. Judges aren't swayed by paper excuses when the proof is sitting right in front of them. And once a judge says it out loud, the damage is permanent.
So he doesn't pick up new cases.
You haven't revoked his bond, is what he's asking.
Yes, I'm revoking his bond. I'm setting it at 20,004 right now. You know, but if you bond him out, that's your choice. But I'm going to continue with the same things that I'm doing, and I'm now going to have him come twice a week to test with me. And the next time he tests positive, and I don't care what it is, the bond is going to end up
The hammer
even higher.
drops, bond revoked, reset to $20,000, and twice weekly drug tests if he bonds out. Translation? The court doesn't trust him on the street. The judge is saying, you'll stay in custody until we can confirm your story, and if you buy your way out, I'll test you so often that deception becomes impossible. This is how instant karma works in court. The more you try to cheat, the tighter the leash gets.
They have mental health caseloads. They have the first thing that needs to happen is we have to have him evaluated, speak to a clinician. They can tell us which the best path to go forward. They may say he needs intensive outpatient treatment. They may say he needs SADF, which is an inpatient facility. I don't know until we have him evaluated. But understand, I like your son. I want the best for him. I really truly, and he doesn't get it.
No, because we watched on TikTok him being in front of your court, and we're going, what the heck is that doing on TikTok?
Quick twist. This judge live streams his proceedings, and the parents even mention seeing their son's case on TikTok. This shows you just how public courtroom accountability has become. Every excuse, every plea, every eye roll can be clipped and replayed a million times. Instant justice meets instant virality, and for defendants, that spotlight is unforgiving.
The loving father, I would be in the same position as you, but I want to keep him clean and sober. That's the bottom line. I've tried to do it the other way. It's not happening, and he's fooling us. So the only recourse I have is this. So if we can set it to your ASAP, hopefully we can have the report back by Friday. At the latest Monday, they will tell us which is the correct course to go, and then we can all sit and talk and decide what to do. At the end of the day, if you want me to just do nothing and
I'd rather you help him.
if you want me to let him go and just fend for himself, then it's on you. But know this is that what you guys are doing now, it's not working. He's slowly killing himself, as evidenced by his demeanor, the way he looks. He's killing himself slowly. And before long, he's going to...
Even here, the parents keep pleading for treatment over punishment. And it's heartbreaking, because they're not wrong about the need for rehab. But notice the judge's tone. He agrees rehab is needed, but he refuses to ignore the lies. Compassion without compliance is useless in his courtroom. The parents are fighting the wrong battle. They want leniency. The judge wants honesty.
Felony. They're willing to provide that to me upon your oral consent to that. Okay. Pre-trial, did you hear that? Okay, great. Thank you, Judge.
So getting him in more trouble.
No one's in more trouble. Do you not see what I'm trying to do? If we wanted to put him in more trouble, we charge him with additional offenses.
Isn't that what he's trying to do?
No. We're not here to punish and enslave and to kill. We're here to help. And sometimes that may require this. Out there, it's not working.
Do I have your word that it's not going to come back?
No, I don't make the charging decisions. I'm not going to give you any kind of word. I'm going to give you my word that I'm going to try to help him as much as I can. But I need your help with that as well. Look, I don't want to have any discussions until with the case, with anything as well. Hold on a second. Hold on. Wait a second. Hold on. Just about giving the records to Mr. Haddad. Hold on a second. until he talks to his lawyer, we shouldn't talk about the case at all. My only concern now is being clean and sober. That's my only concern at this point. Okay? So we're going to take him back. We'll have him TRAS as soon as possible. We can set it for Friday. Hopefully we can have the records back by then as far as what the thing is. And we'll go from there. Okay?
Judge.
Yasha.
Yeah,
What do you got?
when can I come back to follow up on this matter? Can I come back tomorrow?
When can we have him TRAS?
Monday, because he has to be processed today. So, can you,
Wait, Cameron, man.
I can see if somebody can come to hold it.
What day you say?
I'm just trying to keep this stuff out of evidence, so.
And so let's say we take him in now, he gets processed today, he's in POP tomorrow.
Not talking from.
It
Know
doesn't
that
get
this is
brought
live
back
stream, but
before
you're
tomorrow,
talking
then yes,
about
let's
part of the
stay there.
case.
Let's do Tuesday, just to be safe and have the report.
Next Tuesday.
If it's back sooner,
Oh, you mean for the report to be back? Oh, okay. But I'm talking the actual evaluation. When do you think? Maybe Wednesday? Friday.
because it has to be processed. I don't know how long it's gonna take.
Private issue.
Okay. All right. Okay. I'm going to try to have him evaluated as quick as possible. Hopefully we can have it done by Friday and the report back by Monday or Tuesday. Okay. I'm going to put him back now. So Yasha, if you'd like, we'll have you call to holdover so you can talk to Mr. Terrell now. Is there anything else you wanted to add?
Judge, I confirm whatever Mr. Terrell just said, about the fact that he needs help. He needs to use his medication. I believe that if he does start using the medication, it will help his situation. I don't think jail time or incarceration is the solution. I really think that he needs help with his medication and some sort of rehab to get out of the situation he is in right now. I am actively working on both cases, the misdemeanor and the felony. I have provided some evidence to the felony prosecutors about the situation, and I'll keep checking back with them. If I have to go every day, I will.
Okay. And I trust that you will, Yasha. But unfortunately, due to him bringing a Whizzinator into the drug testing room to try to, fool us, it's unacceptable. And I'm going to revoke his bond because of it. We're going to keep him. We'll try to have him, TRAS as quick as possible to see how we go forward.
Yes, and let's get him TRAS, and then I will look at the report, and I will discuss it with him and his family. Okay.
Look, at a minimum, the TRAS will tell us which way they believe is the best course of action. I will leave it to you guys to decide whether you want to do it or not. If you don't want to do it, if you just want to, let him out and fend for himself, it's up to you guys. I will offer my services to you for free.
This line is striking. The judge literally offers free treatment resources if the family cooperates. That's not just punishment, it's opportunity. But it's a conditional gift. He's saying, take the help on my terms, or watch your son rot under the weight of his choices. It's harsh, but it's also a real chance at change. The tragedy is, too many defendants ignore that olive branch.
So, Judge, that's...
To further charge?
I'm not going to personally charge Judge, but I think that the state has a right to know about this if he's violating bond conditions for our purposes. I don't know what it's going to be used for yet, but I think that the state and defense have a right to have this information, Judge.
No. I know. I don't want to add further fuel to the fire and damage. I don't think it's fair.
How is that, Judge? He's violating your conditions,
and he's going in there now.
I understand, but you don't think that the state has a right to this information?
I don't know. Let me look into it. I'll get back to you on it.
Yes, Judge. I don't disrespect the court. I defer to your judgment.
I understand.
I believe that.
Let me talk about it, and then I'll get back to you tomorrow.
Okay.
And we'll talk about it.
This hearing was a roller coaster of excuses, parental pleas, and judicial fire. The defendant tried to cheat a test with a Whizzinator, failed to stay sober, and looked impaired in court. The judge responded with zero tolerance. The bond was revoked at $20,000. An in-custody evaluation was scheduled within days, and a roadmap for treatment was provided, but only under strict compliance. Takeaway: courtrooms aren't blind to clinical needs, but accountability always comes first. You can argue ADHD, Tourette's, rehab gaps, all valid, but if you lie to the system bites back. If this breakdown shocked you as much as it did us, smash that like button, drop your thoughts in the comments, and hit subscribe for more judge roasts, courtroom drama, and instant karma moments.